Intellectual property, or IP, is everywhere. Music on your phone, the brand of your shoes, the software you use, and even new medicines. But here's the challenge: IP is created in one country, yet it often crosses borders instantly. A book written in Argentina can be sold in Spain. A trademark registered in Japan can be copied in Kenya. An invention patented in Germany can be produced in China. That's why international rules are necessary. Already in the 19th century, countries realized they had to work together. The Paris Convention of 1883 protected industrial property like patents and trademarks, and the Berne Convention of 1886 protected copyright for books, music, and art. Today, the international framework is coordinated by WIPO, the World Intellectual Property Organization, a United Nations agency. Treaties like TRIPS, the Madrid System, and the Berne Convention create common rules so that innovation and creativity can be protected across borders. In this lesson, we'll learn the key vocabulary of international IP law and practice using can and cannot to explain rights and restrictions in the global system. This is part of our full legal English course for lawyers and professionals. For complete lessons, live sessions, and expert support, join our legal English community. The link is in the description. By the end of today's class, you will understand how international treaties create a framework for protecting intellectual property across borders. Use can and cannot to describe rights and restrictions. For example, an author can protect their book under the Berne Convention. A company cannot use a trademark that is already registered internationally. We will apply vocabulary connected to global IP law, WIPO, TRIPS, Madrid System, Berne Convention, copyright, trademark, patent, and licensing. We will also practice with real-world case studies where lawyers explain what businesses can and cannot do when protecting their IP abroad. Let's start with a story. A young author in Mexico publishes her first novel. She asks her lawyer, "If my book is sold in France, can I still protect it there?" The lawyer replies, "Yes, you can. Thanks to the Berne Convention, your copyright is automatically protected in more than 180 countries." Meanwhile, a startup in Kenya designs a new logo for its brand. The founders ask, "Do we have to register in every country separately?" The lawyer explains, "No. You can apply once through the Madrid system and extend trademark protection to many member countries." Finally, an inventor in India develops a new medical device. He wants to protect it worldwide. The lawyer clarifies, "You cannot get a single global patent, but you can file an international application under WIPO's Patent Cooperation Treaty, PCT, which makes it easier to apply in many countries." These stories show why international frameworks are essential. They help lawyers explain what clients can do to protect their intellectual property across borders and what they cannot do. Intellectual property, or IP, means creations of the mind, inventions, artwork, books, logos, even software. For example, intellectual property rights encourage innovation and creativity. Let's imagine a software company in Brazil develops a new app. Without IP law, anyone could copy it immediately. But with copyright and patent protection, the company can control its creation, earn money from it, and grow. That's why countries and the world, through international treaties, protect IP. WIPO, the World Intellectual Property Organization, is the global hub for IP. WIPO administers over 25 international IP treaties. Let's imagine a lawyer in Costa Rica advises a client about registering a trademark internationally. Instead of contacting dozens of countries separately, the lawyer explains, We can file through WIPO's Madrid system. WIPO also runs systems for patents, industrial designs, and geographical indications. It balances the interest of creators, consumers, businesses, and governments. TRIPS is part of the World Trade Organization agreements. It sets the minimum standards of IP protection worldwide. For example, TRIPS requires member states to provide copyright protection for at least 50 years after the author's death. Imagine a country is joining the WTO. It must align its national laws with TRIPS rules, covering patents, trademarks, copyrights, and more. A lawyer explains you cannot ignore TRIPS. All WTO members must comply. TRIPS creates a common legal floor for international IP law. The Madrid system is a fast and cost-effective way to register a trademark in multiple countries. The Madrid system allows companies to register trademarks in many countries with one filing. So let's imagine a Kenyan coffee company wants its logo protected in Europe, Asia, and North America. Instead of filing separately in each country in those three continents, the lawyer explains we can file one international application through the Madrid system. This system helps businesses expand globally while protecting their brands. The Berne Convention is one of the oldest and most important IP treaties. It ensures that copyright is automatic in all member countries. The Berne Convention protects authors' works abroad without registration. For example, a Mexican novelist publishes her book. Thanks to the Berne Convention, she does not need to register it separately in France, Japan, or Canada. Protection is automatic. This treaty makes copyright borderless. Copyright protects works of art, literature, music, software, films, and more. An example of this is that copyright prevents unauthorized copying of books and music. You can imagine a band in Chile records an album. A company in another country tries to sell copies without permission. The lawyer says they cannot do that. Your copyright is protected internationally under Berne. Copyright gives creators control and ensures fair payment for their work. A trademark is a brand identity, a logo, a word, a symbol that tells consumers this product is genuine. A registered trademark protects a company's brand. Let's imagine a company designs a new logo. Another business copies it to trick customers. The lawyer explains you can stop them. Your trademark is registered internationally through the Madrid system. Trademarks protect reputation and consumer trust. A patent protects inventions like new machines, medicines, or software for about 20 years. Licensing means giving others the right to use your IP in exchange for royalties. For example, the company patented its invention and licensed it to others. Imagine an inventor in India patents a new medical device. Instead of producing it himself, he licensed it to a European company. The European company can sell it, and he earns royalties. This combination, patent plus licensing, allows innovation to spread while rewarding the creator. In international IP law, can is used to describe rights and possibilities. It explains what someone is legally allowed or able to do. First example, an author can protect her book under the Berne Convention. This means her copyright is automatically valid in over 180 countries. The second example, a company can register its trademark through the Madrid system. Instead of filing in 20 countries separately, one application can cover them all. Third example, inventors can apply for patents in multiple countries via the PCT, the Patent Cooperation Treaty. This simplifies protection worldwide. Let's imagine a designer in Kenya creates a unique logo. She asks her lawyer, "Can I protect this outside Kenya?" The lawyer says, yes, you can. Through the Madrid system, you can register in many countries with one application. So remember, can shows the rights and opportunities that treaties give to creators. In IP law, cannot is just as important as can. It shows restrictions, things that are not possible or not allowed. First example, you cannot get one single worldwide patent. The PCT makes filing easier, but every country still decides whether to grant protection. Second example, a company cannot use a logo that is already registered. Trademark law stops competitors from confusing consumers. The third example, an author cannot stop criticism if it falls under fair use. Copyright protection has limits because the public also has rights. Let's imagine an inventor in India asks, can I get one global patent? The lawyer explains, no, you cannot. The PCT helps, but there is no single worldwide patent. Each country makes the final decision. Or a company in Spain asks, can we use a famous American brand in Europe if it's not registered here? The lawyer answers, no, you cannot. That would be trademark infringement under the Madrid system. So, cannot highlights the boundaries of IP rights, what the law forbids or limits. To register a trademark internationally means to protect your brand in many countries with one application through the Madrid system. For example, the company registered its trademark internationally to protect its brand. Imagine a coffee company in Ethiopia designs a new logo. The founders worry, if someone copies our logo in Europe, can we protect it? The lawyer explains, yes, you can register your trademark internationally through the Madrid system. One application gives you protection in over 120 countries. This phrase is central in business law. It shows clients how to expand globally while protecting their identity. To protect copyright abroad means that your creative works are automatically recognized in other countries through the Berne Convention. Let's look at an example. The author's book is protected abroad under the Berne Convention. Let's imagine a story here. A songwriter in Mexico releases her music online. She asks, if someone sells my songs in Spain, can I protect them? The lawyer explains, yes, because of the Berne Convention, your copyright is automatically protected abroad. You don't have to register in every country. This phrase shows how international law protects artists across borders without extra formalities. To apply for a patent under WIPO means to file through the Patent Cooperation Treaty, or PCT. This doesn't give one global patent, but it simplifies applying in many countries at once. Let's look at an example. The inventor applied for a patent under WIPO to seek protection in several countries. An engineer in India invents a new solar panel. He asks, do I need to file in every single country? The lawyer explains, no, you can apply for a patent under WIPO's PCT system. With one application, you can start the process in 150 countries. But remember, each country still decides if they will grant the patent. This phrase helps lawyers explain the opportunities and limits of global patent protection. To enforce IP rights means to use the legal system to stop others from violating your intellectual property. This can include lawsuits, injunctions, or asking customs to seize counterfeit goods. Example, the company enforced its IP rights against counterfeit goods. Let's imagine a Swiss watch company discovers fake watches being sold in Asia. The lawyer explains you can enforce your IP rights. Under TRIPS and WIPO rules, customs can seize counterfeit products and courts can order damages. This phrase is critical for showing clients that protection is not just on paper, it can be defended in practice. In the international IP framework, some expressions are used so frequently in legal, business, and policy discussions that every lawyer should know them. Piracy is used to describe illegal copying or distribution of works like movies, music, and software. For example, the software company launched a campaign against online piracy. IP theft, stealing ideas, a common way of describing unauthorized use of intellectual property. The firm accused its competitor of IP theft when the same design appeared in their products. Brand identity, the combination of logo, name, colors, and reputation that distinguishes a company. For example, global businesses invest heavily to protect their brand identity. Knowledge economy. Modern economies are powered less by raw materials and more by research, creativity, and intellectual property. For example, strong IP protection is essential in the knowledge economy. Patent troll, a critical term for companies that hold patents only to demand money from others instead of producing real products. Let's look at this example. The court decision limited the activities of patent trolls. Creative Commons, a system of flexible licenses allowing creators to share works under specific conditions. The article was published online under a Creative Commons license. These expressions are professional tools. They help you follow international IP debates in law, business, and policy with confidence. A group of film producers in Argentina release a movie. They worry, if our film is shown in Europe or Asia, can we protect it? The lawyer explains, yes, you can. Thanks to the Berne Convention, your copyright protection automatically applies in all member countries. At the same time, a technology company in Germany has created a new logo for its software products. They ask, can we protect this worldwide? The lawyer replies, yes. You can file one application under the Madrid system to register your trademark in multiple countries at once. Meanwhile, a team of scientists in South Africa develops a new medical treatment. They ask, can we get one worldwide patent? The lawyer clarifies, no, you cannot. There is no global patent, but you can use WIPO's Patent Cooperation Treaty to simplify filing in many countries. And finally, a fashion brand in Italy discovers cheap copies of its handbags being sold online. They ask, can we stop this piracy? The lawyer advises, yes, you must enforce your IP rights. Under TRIPS and WIPO rules, you can take legal actions against counterfeiters. The lawyer concludes, this is the reality of the knowledge economy. Ideas and creativity travel across borders, and intellectual property law tells us what we can and cannot do to protect them internationally. This wrap up shows how international treaties, grammar, and key expressions come together in real professional practice. Let's review what we learned today about intellectual property in the international framework. First, we practiced vocabulary terms like WIPO, TRIPS, Madrid System, Berne Convention, copyright, trademark, patent, and licensing. These are the building blocks of global IP law. Second, we studied grammar, can to describe rights and possibilities, like a company can register a trademark internationally through the Madrid system, cannot to describe restrictions and prohibitions. You cannot obtain a single worldwide patent. Third, we worked with legal phrases, register a trademark internationally through the Madrid system, protect copyright abroad under the Berne Convention, apply for a patent under WIPO using the PCT system, enforce IP rights against counterfeiting and piracy. Fourth, we explored key expressions used in professional discussions: piracy, IP theft, brand identity, knowledge economy, patent troll, and Creative Commons. Finally, we told a wrap up story. International clients, film producers, tech companies, scientists, and fashion brands learned what they can and cannot do to protect their intellectual property across borders. Now you have the tools to explain IP frameworks step by step in clear and professional legal English. Intellectual property is a key part of international law and global business, but this is just one area where legal English matters. In our legal English community on school, you'll get full access to beginner, intermediate, and advanced lessons, live sessions with expert teachers, and a private community of lawyers and students to practice with. Click the link in the description and join us today. Keep building your legal English step by step.